we want to get right now to the network for more information about the Supreme Court just issuing that opinion outlawing race as a factor in college admissions.
To undo. So that may sound very wonky and lawyerly, but that's a smackdown. That is some serious language going back and forth between these two sides. Really not seeing eye to eye on any of this. So stand by, because I think that audio will continue from the court, where I would expect some dissenters to weigh in as well.
Great. Let's bring back in Roger Severino as well for some more reflections as you've been listening to our guest, Jonathan Turley, and of course, Shannon Bream, our chief legal correspondent. Roger.
So on the back and forth with the dissent, Sotomayor during the oral arguments made a structural racism argument, saying that simply being African American means you're going to face some sort of discrimination just by the nature of our society, period. And that you could use a check the box, and that's a good proxy. The Supreme Court rejected that. Race alone is not the overriding factor of human existence. And it is going to allow things like, did you struggle? Did you face discrimination? And that means you overcame obstacles. And that applies for people that are minorities and non-minorities, right? There could be whites in a majority black area that face discrimination. And it's a question of, are you able to overcome obstacles? Where the dissent is going down the lines of, it is different in this country. Blacks' experience is unique, and you don't need the personal stories to back it up. It's just a given. And the court is rejecting that. It's saying we have to treat every individual as an individual, because that is what the Constitution requires. We actually have a colorblind Constitution. We fought a civil war to eliminate race as a decision maker, as a way we value people. And that is the just outcome. When I actually applied to Harvard Law School, I was faced with the same decision. I benefited from affirmative action going through college, and I had an Asian girlfriend who did not get the same open doors thrown wide, and I had to stop. And my story is important, my background is important. I only speak Spanish to my kids, but I did not just check the box. I could not live with that stigma where I would get a benefit where Asians would not. And we all have to be able to, the genius of America is we have that equal opportunity. We cannot have a country where we enforce equality of outcomes, because it's bad for minorities and non-minorities alike.
And Roger, at the end of the day, the majority of the court essentially made this ruling saying that affirmative action violates the Equal Protection Clause of the 14th Amendment. For the average American sitting at home who maybe doesn't know what the 14th Amendment is or what the Equal Protection Clause is, can you just explain it for him?
Sure. This is in the wake of the Civil War. As the Chief Justice said, it was the second American founding. The racial question was the stain of the original Constitution that it did not solve. It took the Abraham Lincoln, it took the North, it took the Union to restore and recognize the fundamental human dignity of African-American slaves. And the 14th Amendment guaranteed equal protection for all. And that means it applied against the states, who were the ones that were engaging in the discrimination. And it was the promise of liberty that was made very explicit in the Declaration of Independence, that we are all created equal. And the Equal Protection Clause was a fulfillment of that promise. And it has to be enforced. And the Supreme Court, this is one of its best moments, as it did with Brown versus Board of Education, saying that separate is not equal in our schools. It has stood up to say now that that same principle applies when you're trying to push one race up and another down for so-called benign reasons. It is not a benign reason when you're saying you cannot enter here because of your race, and some of the race is going to be allowed in. And that's exactly what was happening to Asian American students at Harvard. There was a hard cap at around 20%, and lo and behold, once this litigation came around, it jumped because Harvard knew what was coming, right? Did all of a sudden Asian applicants become more qualified, or did Harvard stop discriminating against them?
Bill, read the New York Times headline tweet that we just got.
Roger, we'll just have you respond to this. So the New York Times just tweeted about this decision, and they're writing in part, quote, breaking news. They're talking about the ruling. They say the major ruling, quote, curtails race-conscious college admissions in the U.S., all but ensuring that elite institutions become whiter and more Asian and less black and Latino. Your response to that?
Harvard's class of 2026 is going to be 42% white. If the problem is we have wealthy people getting a disproportionate benefit, that's Harvard's problem. Again, they're around 82% of the students admitted come from wealthy backgrounds. And Harvard could fix that. If they wanted to really value socioeconomic diversity, they could take income into account in a much greater way, or familial wealth into account, but they're not. They're still allowing legacy admissions where if your family was well connected and went to Harvard, then you get this boost up because it's their club. And they want to choose who exactly gets into their club. And it's been exclusionary against people of lower economic status. They could fix that if they want to. If they cared about true diversity, they could have thought about intellectual diversity, get people from around the country in different circumstances. They don't. They recruit from elite institutions, and they realize that, well, this doesn't look good according to their metrics on race. So then they start including artificial boosts based on race. And it boosts a lot of folks that are really quite well off, right? I happen to have grown up poor. I was not the standard Harvard student when I went to law school. Harvard could fix that if they did greater outreach based on socioeconomic status. They have not. And that would have had a greater impact on race as they were looking for, but they've chosen not to.
Roger, stand by for us. Jonathan Turley, if you're
And we've been listening in there to the network as they've been discussing the Supreme Court ruling today. That 6-3 decision, the court striking down admission plans at Harvard and the University of North Carolina, the nation's oldest private and public colleges there, using race as a part of their decision for admission. We'll be right back.